So hi everyone, we are beginning up with our first panel discussion for the IPR Gorilla Virtual IP Conference happening at Eastern Standard Time Zone. So the topic for the first panel discussion is how innovation is changing the IP industry. So over to you all the panelists for the introduction and Greg as moderator. Thank you.
All right, hi everyone. I hope you can see my screen. My name's Greg Mayer. I am a patent attorney, and my technical background is aerospace engineering. I'm based near Chicago in the US, and I'm with a firm called Scale LLP, which is, speaking of innovation, a very innovative firm that has been remote even before the pandemic. When the firm was founded, I think in 2017, they set up as being a remote so-called distributed firm. And there's a few other firms like that that I'm aware of in the United States, but it's definitely different than a traditional law firm. And so let me move on. And our next introduction is Renata. If you want to introduce yourself, please.
Hi, everyone. Hi, Greg. Thank you. First of all, I want to say thanks for the invitation. And I'm an IP lawyer in Brazil. I work with transfer of technology and data privacy, and it will be my pleasure to join this section with you.
Okay, and our next panelist, Dr. Enrico Bonadio. I'm probably mispronouncing it, Bonadio, sorry. You want to introduce yourself, Enrico?
Thanks, Greg. I am an IP academic at City University of London, so I am based in London. I teach and conduct research on IP, patents, copyright, trademarks, all IP. And I come from practice. Before joining academia, I've been litigator, IP litigator in Italy, my original country, litigating transactional issues on IP. So now I am more an academic, looking at the intersection between IP and technology, amongst other topics.
Great, thank you. And next is Heather Bowen. Heather, you want to introduce yourself, please?
Absolutely, thank you. And my name is Heather Bowen, and I currently serve as commercial counsel for Sixth Sense Insights, which is a leader in account-based marketing. I'm also of counsel at the law firm of Sullivan and Fontanez, and I've spent a lot of time in-house focusing on startup transactional matters, intellectual property, technology transactions, media, data privacy, and security as well. And then I also serve as president of the board of directors for multiple organizations, and I'm a classically trained musician. So I'm definitely glad to be on this panel, and thank you all for attending.
Great, thanks, Heather. And then we have Neelmegh. If you want to introduce yourself, please.
Hi, everyone. This is Neel. I'm based out of India. I work for Baker & Hughes, oil and gas equipment major. So our company is headquartered in Houston and London. I support the internal team in terms of all the IP needs, such as IP risks and how do we mitigate them, and also most of the innovation lifecycle, right from capturing the new ideas to evaluating them whether or not it's worth filing them, and then up to drafting and prosecution support. So that's briefly about me.
Okay, great. Thanks, everyone. So I just want to pull up our agenda real quick, and then that's the end of we don't have a lot of slides, just to introduce ourselves essentially. But so the first thing we're going to talk about is innovation in the practice of law, meaning, innovation as it relates to doing the services that we do for clients to help them protect intellectual property. And then the next topic we'll try to cover is innovation in what I'm terming back office functions, such as billing, accounting, filing things with courts and patent offices, that sort of thing. And then another topic we want to talk about is just innovation in the organizational structure of the organizations, both law firms and in-house departments at corporations that serve the IP function. And I will try to keep track of time as the moderator and hopefully leave some time for questions and answers. And so my first question for our panelists, I think, is for Neel. Neel, I know there have been a lot of innovations in recent years in some of the software tools that are used for patent searching and other types of research. Do you want to tell us your thoughts on those advances and innovations?
Definitely. Yeah. Thanks for setting the background, Greg. Yeah, I've been in this field of searching for a while now, almost 15 years, I would say. So right from the days when searching for a title and an abstract and providing that was a big thing back in the day, but right now I think it's something which is clicks away. So we have come a long way in terms of the tools, I would say. Right from, if you recollect the earlier version of Derwent was Thomson, and even before that, we had text-based searches, and there was no intuitive way of searching. You had to almost have a coding kind of a background to really go and search what you wanted to do. And I think from there, if I look back and see how we have really traveled, I think we've come a long way, I would say. For example, I've been evaluating the search tools to increase the productivity and see how best we can provide insights faster and quicker and in an effective way, so that our teams can focus on what they're trying to do, which is the technical stuff. And while we try to see how we can bring insights, whether be it from the technology or the patenting world. So in that sense, I would like to highlight a few things here, that the natural language processing has come a long way in its adaptation into the search tools. So I think they have evolved. If I were to put in a paragraph of text and ask the tool to search, I think it does a much better job today than what it used to do even a few years ago. So NLP is something which has really come a long way. And then I see that after we have a large data set, how do I visualize and sort them into categories that make sense? That was something that we were struggling, having to spend a lot of manual hours, going through the sieving through the results with a lot of noise in it and trying to pick out the signals from there. But once you still have the signal, even if it's 1,000 data set, it used to take a lot of time in terms of categorizing them, whether it's A or B or C. But right now, I see tools, not especially that have been integrated into the pattern databases, but some of the individual tools that I've tried, they're standalone tools. If I, let's say, train the tool and tell them that, okay, these are the 10 patterns that belongs to category A, these are the other 10 patterns that belongs to B and C, then if I train it for maybe, say, 15 minutes, and then I put in thousands of patterns, and I think I will get an accuracy of about at least 90%, because the first iteration we tried it doing it manually to see whether this automation is really doing its job, and I think to our surprise it was right on the dot. So this really helped us cluster these big data sets with signals into different categories. So that's something that's come along in the modern search tools. I will quickly take 3 other points here before I close my note on this. And charting, also, if you see the way the visualization has improved over the years. For example, I'm trying to highlight here the aspects of charting different X and Y domains. For example, if I were to look at a heat map of what companies and what classification codes they're doing, that's much easier with a few clicks now, which was not even available, I think, a few years ago. And if, let's say, I were to generate meaningful keywords out of a patent database, patent data set that I'm trying to analyze, and if I were to make a keyword matrix, keyword versus a keyword, then that would give me a lot of insight about what's happening in the technology space there. If I were to pick an example, let's say in my oil and gas domain, are people really talking about high pressure and temperature downhole, or is it something else? So I would get a very quick trend of such technology areas by doing this charting effectively.
Sorry to interrupt, but I just wanted to ask you if there are specific platforms that you prefer nowadays for patent searching. My most recent experience was using a software package called PatBase that's from a company called Mindsoft that I thought was very good, but I know there's a lot of other really good software. And also the patent offices, like the European Patent Office has an amazing search platform, but I'm just curious, what is your favorite, maybe top one or two search engines, so to speak?
Great question. So we have been all the while using Derwent Innovation, which in itself has evolved a lot. But I've also tried databases like Inography, Patent Scout, and then Patent Scout has its own advantages. I mean, Patent Scout allows us to visualize large data. Patent Scout, I think, now is bought by Inography, but you can still have an individual license to it. The reason I like Patent Scout is you could visualize large data sets in a very meaningful way. I think that's the strength of Patent Scout, and Inography for its display of charting and all that. But again, I would say if I were to pick the two top favorites, I would say Derwent Innovation and Orbit. So I've been throwing a lot of names, but yeah, because I'm from a group where we constantly try evaluating different databases to make our life easier.
Yeah, I think if you don't mind, maybe put a few links in the chat if you could. It might be nice for our audience to just see links to the software platforms that you think are good, because it sounds like you've put a lot of thought and research into it. So moving on, and a little bit of overlap, because I think a lot of what you were talking about was some of the machine learning and artificial intelligence systems that are enhancing patent searching. And Enrico, I think you have a lot of thoughts on artificial intelligence in the context of inventions and copyrighted works, and you've done some research on that, I believe. So you want to share your thoughts on that area, please?
Yes, I mean, as far as concerned, I mean, AI may present both challenges and opportunities, right? For patent offices, for example. First of all, prior art searches. Prior art searches could be, in theory, facilitated by AI, as we know, because, it could be a good instrument that patent examiners and searchers both could use to identify the pertinent, the relevant prior art. So this is an opportunity. But on the other hand, it's also a challenge because, especially when it comes to assessing a non-obviousness and inventive step, right? Inventive step in Europe, non-obviousness in the US. Examiners there might come across difficulties in putting themselves in the shoes of the person skilled in the art, because when AI enters the patentable subject matter, the person skilled in the art becomes a super intelligent expert, because the machine is more intelligent than the human being. The machine is capable of extending the prior art, and so on and so forth. So it is challenging, if not human impossible, for a human being to take into account the huge prior art that a machine can get its hands on. So this is the challenge. So several commentators, patent academics, have stressed the fact, have highlighted, look, for a machine, for a super intelligent machine, everything is obvious. Especially when it comes to combination patents. For example.
Well, I have a question for you, Professor. I think there's decisions from both the United States Patent Office and the European Patent Office that say that an artificial intelligent computer cannot be an inventor. So then my question is, how can AI be the so-called person of ordinary skill if that entity cannot be an inventor on a patent? That's a question I have.
Yes, I mean, the Davos decisions have been quite clear. So the Davos decisions have closed the door. Let's say they have closed the door to patentability of AI, but for the moment, because I guess it was the EPO office, it's also the UK patent office. They said, we understand that AI nowadays creates inventions, but we need to take a decision based on current patent laws. And current patent laws do refer to inventor as a human being, personal. So also the US Patent Office, they examined the literal element of the patent statutes, right? It does say person skilled in the art. Even in Diamond Chakrabarty, the US Supreme Court said anything made under the sun by a man, not by a machine, right? But the same patent offices that have refused the patent on these grounds, they have said, look, we know that there is a debate going on. So our decision now is based on current patent laws. But there was a kind of invitation, or the door has not been closed totally from a policy perspective, leaving the doubt or suggesting that in the future, if the laws change, if there is a legislative willingness, let's say, things may change.
Right. Yeah. So I think we should all stay tuned, because you're right, because the statutes and rules could change. And I guess I'm just thinking about the question I asked in a way, if it is normal practice in industry, depending on the industry, for the inventive community to use AI tools, then maybe it's not such a stretch to use that sort of prior art, and that, you know, the AI will find things that are maybe considered in a separate field in the past, that now are sort of fair game for inventive step and obviousness references.
Yeah.
Please, because we should move on. We have other topics.
Sorry.
No, go ahead. One more thing's fine.
One of the arguments put forward by the Davos people is, you refuse the patent, it's an invitation to cheat, basically. It's an invitation to hide the role played by AI in reaching the invention. So you are sanctioning a lie, basically.
Mm-hmm. Yeah.
Which is an argument, I think. Right. It's an argument we should be taking into account.
Yeah, makes sense. So just Heather, I just want to open up to you, and also Renata after Heather, but what are your views on innovation in the practice of IP law in your experience, Heather?
Definitely. And I think, especially taking it from a commercial transactions perspective, I think that with so many tools that are out there, from software tools and platforms, we think of even, things so simple as Google Docs or Asana or Slack, and even to knowledge-based and management systems, document management systems like Salesforce or HubSpot, and even Lessonly, from an in-house counsel perspective, and I think even as applicable in a law firm context and environment, we're placing a lot of emphasis on these platforms and using technology as the biggest driver for innovation, especially with IP. And so I think that in my practice, for on a day-to-day basis, it's so critical to have databases with readily accessible master's agreements, for example, that can be modified, used with different customers who might be based in different jurisdictions. And I think even more so to, how essential it is to really have a means of streamlining a contract management system and a process using a tool that can not only serve as a validation system, but also be an all-in-one reporting system. So I think there's a lot of innovation and impact that technology is having from a commercial transactions perspective that we can really try to leverage, moving forward in this environment.
Yeah, that's a good point. And I think that sort of building on the keynote session about COVID, this pandemic being an influencer, I think, at least in my practice and my life, I've been using a lot more collaboration tools like you mentioned, and that may be so-called silver lining that we all get better at using things like Google Docs and other collaboration tools to get work done, even though we can't get together physically. So Renata, what are your thoughts on this?
I totally agree with you, but I think that the opportunity is to reuse the tools that are available. I think that IP Office should be aware of the new technologies and consider reuse and not reinvent. Because as you said, are available many tools, and it's more simple to adapt them for the specific IP instead of to reinvent a new tool specific to IP. And I also consider the cloud computing as a big benefit, but we can think how to use it in order to deliver the new services with much more quickly. Because nowadays I think that the clients are looking for quality and the velocity of the service.
Yeah, and during our preparations, I think, Renata, you mentioned that there's been some innovation in the harmonization among the big patent offices all over the world. Do you want to comment on that briefly?
Yeah, I think Oil's IP matters are trying to be on the same page as the importance they are for many trade transactions. But nowadays, I think we have huge harmonizations, law harmonizations, and we can use the tools we have to open an interface and integrate it more rather than centralization. What I mean, I think that nowadays we should thinking about to cooperate, to establish new ways of doing work, not only in your country, but all the while.
Yeah, and I was just going to mention, I think one of the things that came up during our preparation was just, again, talking about AI, some of these translation, like Google Translate, and there's so much more readily available information about prior art from all over the world to all of us because of these amazing translation advances. So I guess moving on to our next big topic, which is sort of the back office, so to speak. Heather, how has innovation in the back office presented itself in your world?
Definitely. I think that there's so much opportunity now more than ever to really take advantage of AI, not only in the law firm context, but also in an in-house department, really to streamline just overall work processes. And so this comes really in the form of performing, for example, due diligence, doing any sort of research throughout the process of whether it be litigation or using the automation of like software templates to create filled out documents, just to have that as part of the overall contract review cycle. So I think that the various platforms that we've been talking about are designed in a way to really reduce a lot of the manual labor and energy that we expound typically on, administrative tasks that could otherwise be used on directly handling some more important client matters. So I think from an IP perspective, AI tools can really assist in not only analyzing large IP portfolios and drawing different insights from those reports, but we can also look at using these tools to complete, billable hours and work on that automatically. So of course, there's big companies out there like, Clio and Timely and ActiveTime And so say if you've just wrapped up a call with a client, you've been, attending a meeting, you're working on a document, then you can use that AI to just bring all those pieces of information together, provide a timesheet based on your tasks that you've completed for that day. And then, of course, that's just going to eliminate a lot of the manual processes that are involved with billables and create that invoice that can just be sent to the client while you maintain a lot of focus on your revenue generation. So I think just like all our panelists have been talking about already with, the impact that AI can have on our businesses, it's just so key to take advantage of that and continue to leverage it.
Great, thanks. I'm just looking at the chat, and a question has come in from Gerard. What is the view on AI tools used in patent valuation? I don't have a lot of familiarity with it. I have seen presentations by people from LexisNexis. They have something called Patent Site that creates this thing that they call a patent asset index that somehow gives a valuation sort of, I think it's just a relative valuation if you're looking at a large portfolio of patents. But for the question for the panel, has anyone used some of these tools for patent valuation? And if so, what are your thoughts on them?
I've never used it, but I think that for valuation, since we have to establish the criteria, all the possibility of a learning machine is real. So I agree that we can do it. I don't know with the sensibility with obviously under review, but I think it's completely possible, mainly because we should only manage how we will learning, we will teach the machine to learn the criteria to apply.
My comment is I believe somebody eventually, a human being, needs to read the claims and understand the industry in which the patent is relevant to really get a valuation. And of course, the valuation is ultimately what would someone pay if it was auctioned off, I guess, a patent or a portfolio. But I do think there's tools that can give you relative values, but I'm not sure that you can get like absolute precise valuation just using AI tools that we have today. But that may change. I mean, just because there's so much data out there, and there are companies that are handling a lot of transactions over the years that will build a database that could maybe give more precise estimates of value. But great question. So I guess one of the other things I wanted to ask is how has innovation impacted the structure of organizations such as law firms and law departments? So Heather, do you want to start off on that topic?
Sure. I mean, I think that there's really a big question that we have to ask is how are we getting, how ready are we and our colleagues, our in-house departments, our law firms, how ready are we to embrace innovation, not only in the terms of investment that the organization has to make with just incorporating technology into everyday practice, but also how ready are these legal departments to embrace innovation as it relates to our behavioral change. And so I think that the belief that innovation and the benefits that it could have on a legal department or in a law firm has to start with the leaders at the top. So our firm partners, our general counsels, our C-suite, really these leaders have to choose to take innovation seriously, to say that, to choose to leverage it and benefit the business or the firm, and who have to be also very actively involved in the technology's impact for the business and ultimately for the client. And so I think there's some good consensus that in some instances, law firms generally don't have a strong reputation for being innovative. So I think that for law firms to really break that stereotype, they first have to address that sort of the attitude that holds them back, saying like, oh, well, you know what, we tried the platform in the past, it didn't work out for us, so we're just not interested in trying anything again. Or otherwise being reluctant to become immersed in a platform that seems to really work unless a vendor can provide some sort of guarantee that the technology will function without any sort of problem. So I think it's being able to just at the end of the day, use innovation to like have that attitude to say, hey, this is a group responsibility. We're going to embrace the way forward of trying to leverage these technologies and not just instead to place that responsibility on one person or just the IT department.
Yeah. So Neil, I was going to just throw it over to you because I noticed that you have a green belt certification, and I also did green belt training at my former company, Hollister, which is a medical device company. What are your thoughts on that, Neil? Have you seen like sort of process improvement efforts to create more innovative structures in the groups you've worked in?
Definitely, I would want to give in a more perspective from the, the in-house corporate, how the structures are changing. I would definitely say that it's still in the initial stages, but the legal has been the last wheel that would move in an organization in terms of embracing. I think I would agree with Heather when she said that the law firms are, in terms of adoption, it's going to be slower. I think it's the same story when you come to a corporate as well. But I think the influences or the push and the pull is much higher in a corporate structure, because if all your other ancillary groups are trying to embrace these new tools, then it will only be natural for even the legal and the IP function to be pulled into those newer domains. For example, in our case, I would say that there are different smaller teams disposed at locations now where they're looking at how we can capture innovation much effectively and how we can help the teams to understand. So previously it used to always be a headquartered down, and it used to be a top down, but now it's going to be a bottom up because of the tools and I would say a diversified approach to this. In that way, the organization structure would change. As I mentioned, the smaller teams are dispersed across. They not only help in educating the technical community in appreciating IP and how they should be able to approach this. There are two advantages to this. One is the in-house innovation, how we can protect. And also what we found is the teams are now able to go trade show, or they are visiting a site, they see a competitor using a similar design or something, they come back and say, hey, you know what, can we do something about it? And that has created a huge impact in us pursuing some of these matters further, which would have easily been ignored otherwise if the technology teams were say, hey, yeah, you know what, let's do our stuff and things like that. So I would say that not only the structure, but also it's creating impact.
Great. Enrico, one of the things that came up in our preparation was like sort of the way forward, and what do we think of like the younger generation of inventors and attorneys that are coming into the IP world? So since you're a professor, you see that young generation more often than we perhaps do. What are your thoughts on what their sort of expectations are and capabilities for changing the way we work in innovative ways?
With the mic. No, I was saying that for sure the young innovators, the young inventors that join my classes are so enthusiastic, so full of energy, and they love AI tools. I mean, one of the reasons why I was pushed to research on this issue is because of my students as well, basically, and telling me how wonderful these tools are to create creative machines, right? Because then, let's remember, these inventions are made by the machine, which is produced by people. So these inventors, they don't create the final inventions. The final inventions is autonomously and independently created by the machine, Watson and the invention machine, the creative machine, Taylor. I mean, all these experiences show us how the creative process, the inventive process, is triggered by a human being. The human being creates the machine, which then comes up with the invention, also in the field of copyright. So my contact with them, with these innovators, is clear. They are enthusiastic, and they are also, however, aware, or they ask for protection, because they are aware of the fact that they spend money, time, energy, effort to create these machines, and they think, but what about the final output then developed by the machine? Can we really think to live in the public domain, the final output created by this machine? At the end of the day, if we live in the public domain, the final output, upstream, the creators of the machine might be disincentivized to create such machines. So,
Yeah.
because we need to take into account, it's true that machines do not need incentives, right? Professor Samuelson in America in the 80s, she said, they just need electricity to work. It's true, they need electricity and they don't need incentives. But the human beings who create such machines, they do need incentives.
Right. Yeah.
And that's what I have perceived by talking to these young innovators.
Right. So Renata, what do you think are some of the challenges and opportunities going forward as we progress into this world of innovation and AI?
In fact, I will make a question for you, Enrico. Do you think that the opportunity for IP offices and professionals are to providing the correct strategy to turn their ideas and actions and the project into money through the IP?
Yes, absolutely. There is demand for protection. I mean, my conversations with these young innovators is they want to understand how it works. They want to understand how the process is, because many they don't know the technicalities, the things that we lawyers we are. So my perception is that they try to understand how they can use patent law to help them recouping the investments first and getting a profit, because there is nothing really wrong in getting profits. I mean, for the work. I mean, they invest time. So after recouping the investments, they also, are happy about making some money to support further projects as well, right?
Right. So I think we only have a few minutes left, so I wanted to just ask the audience if anyone has questions, please I think you can click to share your video and audio, or you can just type something in the chat if you have any questions. But I just want to take a moment to thank the panelists for sharing their insights. I learned a lot, both during preparation for this and during this session, and I hope the audience learned a lot as well. And hopefully we'll get to chat further during the course of today and going forward. And it probably goes without saying, but feel free to reach out to me on LinkedIn or otherwise. Happy to talk further about any of these topics with panelists or audience members. So thanks, everyone. Sure. Well, I guess in closing, I would say that I think we're all experiencing a sort of revolution in this use of machine learning and artificial intelligence. And I think our panel has discussed some great examples of that in how patent offices are managing things and machine translations, and also in the patent search tools that we have. And one thing I wanted to mention that probably people are aware of, but I'm sort of recently becoming aware of in the past couple of years, is there are software platforms, at least in the United States, where you can say, I have an examiner. So like say the examiner's name is John Smith. You can look up John Smith and all the data has been aggregated. So you can say, well, if I have a case in front of John Smith, based on the statistics of cases that examiner has handled, it's whatever, 80% allowance rate. And maybe if you conduct an interview, then it goes up to 85% allowance rate. So there's this sort of what I would call granular data, at least in the United States, on individual examiners, and also in courts you can get similar data for judges that you might be appearing before. And I think the software platforms I'm aware of are both LexisNexis products. But I just wanted to throw that out there. It's something I meant to talk about earlier, but thanks everyone. I think we're all sort of trying to adapt to this new world, and this pandemic has sort of kicked us in that direction in a way, I think, especially with platforms like this that I never would have used a couple of years ago. And we're all trying to learn how to use all these online platforms like Zoom and Google Meet and Hop-In and so forth. So thanks, everyone.
And it was a wonderful session, where we have defined that how innovation will be changing the IP industry in 2021. And we are looking forward to wait for all these things. So thank you, panelists, for joining for this wonderful session. So we have one question from Siva.
So the question is, are there tools that could be used to assist with patent pruning? And the way I understand that is if, a company has a huge patent portfolio and they are trying to make tough decisions about expenses, they may need to drop some patents in some jurisdictions and not pay the taxes or annuities or maintenance fees, as they're sometimes called. Does anyone have experience with using software to help that? Neil, you might have something on that.
Yeah, we recently tried using Orbit Innovation, where they have a automated tool to do the pruning exercise. I would say that they still come up with about 60% or 70% of the data, but manual intervention is required. But it's a huge help when you have a big portfolio to prune and to understand the different levers. You can just change them and set it up in such a way that it'll throw a score to you. At least it'll get you to prioritize the immediate, pruning activities in that way. So Orbit Innovation is something that you might want to try.
Yeah, and I'll comment on this, and this is going to sound political, and I don't mean to be political, but I actually have experience where I think we should have filed in fewer countries than we did. And the reason for that is that there are certain countries, and I'll just throw out Hungary, and Hungary has been going through some political turmoil, I believe, over the past 10 years. And it's very unfortunate. And if anyone is from Hungary on this session or in the audience, I apologize if I'm sounding harsh, but in my experience, the court system in Hungary was not what I consider justice. We had a case where we had a patent we were asserting, and the court didn't even allow our attorneys to appear and decided against us without any arguments. All we had was our written submissions, and that's not typical. So in hindsight, I think if you're in a country where you can trust the government, and I believe in the U.S. we can going forward trust our government. Again, not to be too political, but our Department of Commerce has what are called intellectual property liaisons based all over the world. And in hindsight, I wish I had talked to the intellectual property liaison for Europe and said, hey, we're thinking about, asserting a patent in Hungary. What do you think? And they would have told me, don't bother, because the leader of Hungary has been dismantling the court system there, and it's not justice as we know it in the United States. So I think it's important to look at the climate in the court systems of certain countries, because you may be paying fees and taxes, but you would never really be able to assert a patent in that jurisdiction. Now, of course, it has value maybe for cross-licensing type of things, but sometimes the value is in the ability to assert a patent. And if that isn't really a reality in the countries as you typically would expect, you might not want to pay the fees in those countries. So that's something, again, not to be too political, but that's a reality of an expense that I wish my company had not incurred in hindsight. So thanks for the question. Great question.
I hope, Siva, you got your answer for the question. We also have a quick question from KD. How effective are those tools when we know some patents don't publish informations?
I'm not sure I understand the question, but I will interpret it. I think, patent offices don't publish information. Oh yeah, that's difficult then. I guess I don't really have experience in that, because I've been just really dealing with the United States and European patent offices where the information is readily available. Does anybody have experience in other jurisdictions where perhaps it's difficult to decipher the information from the patent office?
All right, sure. So I think that we have come to the closing of the session.
Okay, thanks.
Thank you so much. Thank you, panelists, for joining for a great session, and I'm looking forward for your valuable participation for whole day. Bye from here.
Thank you.
Okay, bye. Thanks.
Thanks.